My name is Annie Collins, 34 years old, and I have served as a federal judge in Boston for 8 years now. Since childhood, I dreamed of following my father into the legal profession. Never did I imagine that pursuit would lead me to a custody hearing where my own mother would testify against me, claiming I could barely hold a job. The courtroom fell silent until Chief Justice Pearson stood up and said those 11 words that made my mother turn ghostly white. Before I tell you what happened next, let me know where you are watching from. Hit that subscribe button and join me for a story about betrayal, vindication, and healing. I grew up in a quaint Massachusetts town called Millfield, about 40 miles outside of Boston. Our house was nothing fancy, a modest colonial with faded blue paint and a creaky porch swing where my father Thomas would sit with me after dinner. Those evenings were precious, Dad explaining his cases in simple terms while I absorbed every word. He worked as a public defender, not glamorous or high-paying, but he believed fiercely in justice for everyone regardless of their ability to pay. My mother Evelyn had different priorities. While Dad saw value in serving others, Mom measured success in promotions, salary, and status. From my earliest memories, her criticism was constant. "Annie, stand up straight. No one respects a person with poor posture. Annie, that book report is sloppy. Do it again. Annie, second place might as well be losing. Nothing I achieved ever seemed enough. An A- earned a lecture about carelessness. Winning silver in the science fair prompted questions about who won gold and why I had fallen short." Dad was different. He celebrated my curiosity and encouraged my growing interest in law. When I was 10, he brought me to the courthouse for the first time, letting me sit in the back during a simple hearing. I was mesmerized by the procedures, the careful arguments, the structured pursuit of truth. At dinner that night, I announced I wanted to be a lawyer just like him. Mom scoffed. "The legal profession is oversaturated, Annie. Unless you attend an Ivy League school and make law review, you will struggle to find employment. Your father is the perfect example of settling for less." Dad winked at me across the table. "Your mother is right about one thing, Annie Bear. This profession requires hard work and dedication. But if that is your passion, I know you have the brains and determination to succeed." Despite my mother constantly moving the goalposts of her approval, I thrived academically. By middle school, I was taking advanced classes and serving on the student council. Teachers praised my analytical thinking and writing skills, but Mom found ways to minimize these accomplishments. Jennifer Lewis's daughter skipped 2 grades and plays violin with the youth symphony. Have you considered a musical instrument, Annie? The tension between my parents grew steadily through my childhood. Their arguments, though hushed behind closed doors, became more frequent. Dad defended his career choices and salary, while Mom pushed for him to pursue corporate law or politics. Their fundamental values were simply incompatible. When I was 14, they finally divorced. The split was relatively amicable in legal terms, but emotionally devastating. Mom wasted little time moving on. Within 6 months, she had married Harold Preston, a wealthy investment banker from Boston with political connections and a summer house in Martha's Vineyard. Given the choice between living arrangements, I chose to stay with Dad. This decision created an even deeper rift between Mom and me. She seemed to take my choice as a personal rejection, though she never said so directly. Instead, she grew increasingly distant, her visits becoming shorter and less frequent. Meanwhile, Harold had 2 children from a previous marriage, and soon Mom was expecting a baby with him. Her attention shifted completely to her new family. My half-sister Catherine was born when I was 15, and it seemed my mother had embraced a fresh start that conveniently excluded much of her past, including me. Rather than letting this rejection destroy me, I channeled my hurt into determination. If I could not earn my mother's approval through achievement, I would at least prove her predictions of mediocrity wrong. I threw myself into academics with renewed intensity, joining the debate team and mock trial activities that honed skills I would need for a legal career. By senior year, I had earned a full academic scholarship to my father's alma mater, Boston University. When I was named valedictorian, Dad beamed with pride. Mom attended the graduation ceremony with Harold and my half-sister arriving late and leaving immediately after the ceremony. Her only comment on my speech was that I should have worn a more professional outfit and gotten a proper haircut for the occasion. That summer before college, Dad and I took a road trip to Maine. During a sunset walk along the rocky coast, he gave me advice I have carried ever since. Annie, some people will never give you the validation you deserve, no matter what you accomplish. Your mother loves you in her way, but she may never be able to express it in the way you need. That is her limitation, not yours. Live for your own sense of purpose, not for approval from others. Those words became my foundation as I entered Boston University that fall, determined to excel in undergraduate studies before applying to law school. I decided to follow in my father's footsteps but chart my own course within the legal profession. College presented new challenges but also liberation. Away from the shadow of my mother's expectations, I flourished. I double majored in political science and philosophy disciplines that strengthened my analytical thinking and ethical reasoning. Professors noted my thorough research and sharp questions in class discussions. Dad remained my rock. Though living on a tight budget, he called weekly and visited monthly, bringing homemade lasagna and listening attentively to my experiences. When I struggled with an especially difficult constitutional law, Professor Dad spent hours helping me understand complex precedents and their applications. Summer breaks were dedicated to internships. After freshman year, I worked for a small family law practice in Millfield. Sophomore summer, I secured a position with the district attorney's office. By junior year, I had earned an internship at Sullivan & Pierce, a prestigious Boston firm specializing in civil rights litigation. These experiences confirmed my passion for the law while teaching me practical skills no classroom could provide. I witnessed the grinding machinery of justice with all its imperfections and occasional triumphs. I saw how good lawyers could make profound differences in clients' lives, just as my father had always done. Graduation came quickly. I finished summa cum laude with Dad cheering loudly as I crossed the stage. Mom sent a generic card with a modest check but did not attend. Her absence stung less than it might have years earlier. I had grown accustomed to her distance and had surrounded myself with people who genuinely supported my ambitions. Law school at Boston University followed immediately. The workload was intense, the competition fierce, but I thrived under pressure. First-year grades placed me in the top 5% of my class, earning me a spot on law review. When I called Mom with the news, her response was predictably underwhelming. Law review is certainly helpful for employment. Have you considered transferring to Harvard? Their law review carries more prestige. I did not transfer. Instead, I committed fully to excelling where I was. By day, I attended classes and contributed to law review. Evenings and weekends were consumed by study groups and outlining cases. Social life became nearly non-existent, but I accepted the temporary sacrifice for my larger goal. My dedication paid off. Upon graduation, I received multiple offers from respected firms. After careful consideration and lengthy discussions with Dad, I accepted a position at Harrington Walsh & Bennett, a mid-sized firm with a strong reputation for litigation excellence. The starting salary was impressive, especially compared to my frugal student lifestyle. When I shared the news with Mom during a rare lunch meeting, she immediately asked about larger firms that had recruited from my class. Sanderson & Black hired 3 people from Harvard this year. Their starting bonuses alone are substantial. Did you apply there? I did, I replied evenly. I preferred Harrington's culture and mentorship opportunities. She sighed. I suppose it is a start. Harold knows several partners at Whitman & Lee. He could make an introduction if you are interested in lateral movement. I thanked her politely but declined. My career would be built on merit, not connections or shortcuts. Those early years at Harrington tested my limits. I arrived before senior partners and left after they did. Weekends became extensions of the work week. I volunteered for difficult cases, drafted meticulous briefs, and prepared exhaustively for court appearances. Mistakes were few and quickly corrected. Senior partners began requesting me specifically for their litigation teams. Clients commented on my thorough preparation and clear communication. By my 3rd year, I had successfully first-chaired several significant cases and developed a reputation for unflappable composure under pressure. Patrick Walsh, one of the founding partners, called me into his office after a particularly challenging victory. Annie, Judge Franklin has approached me about a judicial clerkship opening. She specifically requested you. It is an unusual move typically reserved for new graduates, but she was impressed by your performance in her courtroom last month. Judge Margaret Franklin was a legend in Massachusetts legal circles, known for her brilliant legal mind and exacting standards. A clerkship with her would be invaluable for my career. The position would mean a substantial pay cut, Patrick continued. But the experience and connections would be unparalleled. The firm would welcome you back afterward, potentially on partner track. I accepted without hesitation. Working alongside Judge Franklin proved transformative. She demanded excellence, but offered mentorship that shaped my understanding of judicial responsibility. She taught me to see beyond technical legal arguments to the human implications of each ruling. A good judge knows the law, she often said. A great judge understands how the law affects people's lives. One evening, as we reviewed a complex case, Judge Franklin made an unexpected comment. "You have remarkable judicial instincts, Annie. Have you considered that path rather than returning to private practice?" The question planted a seed. When a federal judicial vacancy was announced the following year, Judge Franklin encouraged me to allow my name to be submitted. At 36, she had been among the youngest federal judges appointed in her day. At 26, my candidacy would be exceptionally rare. "You are young," she acknowledged. "But your qualifications are outstanding. The bench needs fresh perspectives and sharp minds willing to grow into the role." The nomination process was grueling. My youth became the primary focus of questioning. Every case I had handled underwent scrutiny. My personal life limited as it was faced examination. Through it all, Judge Franklin guided me, having navigated similar challenges decades earlier. Dad attended every hearing, sitting quietly in support. Mom did not appear once, though. Harold sent a formal note of congratulations on his company letterhead. The confirmation finally came by a narrow margin. At 26, I became one of the youngest federal judges in district history. The achievement felt surreal, the responsibility enormous. Judge Franklin hosted a small celebration, raising her glass with words I will never forget. To Judge Annie Collins, may your rulings be wise, your mind remain open, and your commitment to justice never waver. Dad hugged me that night with tears in his eyes. Your mother should see you now, he whispered. She was wrong about you. She was always wrong. Transitioning to the bench brought unexpected challenges. Attorneys who had been colleagues now appeared before me as advocates. Some particularly older male lawyers subtly tested boundaries, addressing me as young lady or Miss Collins until firmly corrected. My courtroom management style evolved through trial and error. I established a reputation for thorough preparation, expecting attorneys to demonstrate equal diligence. Cases moved efficiently in my court with punctuality and procedural compliance strictly enforced. Initially, this earned me the nickname the Clockwork Judge among court staff, though it was spoken with growing respect rather than derision. Outside the courtroom, I carefully rebuilt a personal life that had been largely sacrificed to career ambition. I joined a rowing club on the Charles River, finding peace in the rhythmic exertion at dawn before court sessions began. I reconnected with college friends, many now established in their own careers. At a legal conference in Chicago during my second year on the bench, I met James Harrington, a professor of constitutional law at Northwestern University. Our connection was immediate intellectual debate flowing easily into personal conversation. Unlike previous relationships that had withered under my demanding schedule, James understood professional dedication. Our long-distance relationship progressed through lengthy phone conversations and alternating weekend visits. When James accepted a position at Boston University Law School 18 months later, our relationship deepened. He proposed on Christmas Eve with a simple sapphire ring and promises of partnership rather than possession. We married the following spring in Judge Franklin's garden, with Dad proudly walking me down the aisle. Mom attended the wedding with Harold and my half-siblings, maintaining polite distance. Her gift was expensive but impersonal, a crystal vase from a high-end department store with a card signed by the entire Preston family. She departed immediately after the reception dinner, citing Catherine's dance recital the following day. James and I settled into a brownstone in Beacon Hill, establishing routines that accommodated both our careers. We hosted small dinner parties for colleagues traveled during court recesses and built a life balanced between professional achievement and personal fulfillment. 2 years into our marriage, I discovered I was pregnant. The timing seemed impossible with my court docket fully scheduled for months ahead, but James never questioned whether we would make it work. Together, we prepared for this new chapter, converting the home office into a nursery and researching family-friendly policies in the federal judiciary. Lily Ann Collins Harrington arrived after 36 hours of labor, perfect and determined from her first breath. Returning to the bench 8 weeks later proved the most difficult professional challenge I had faced. Exhaustion clouded my thinking during long hearings. Case files were reviewed during late-night feedings. The mythical work-life balance remained elusive, yet somehow we managed. Court staff proved unexpectedly supportive. My judicial assistant, Carol, rearranged schedules to accommodate pediatrician appointments. Bailiff Ron became an honorary grandfather figure, proudly displaying Lily's photo beside his own grandchildren. Judge Franklin visited regularly, bringing children's books and practical advice about motherhood in the judiciary. The women who came before us had no blueprint, she told me, cradling Lily while I reviewed a complex brief. We are still creating it as we go. Be gentle with yourself, Annie. By Lily's first birthday, I had found a sustainable rhythm. James adjusted his teaching schedule to maximize our shared parenting time. We secured a wonderful nanny named Teresa for the remaining hours. I learned to compartmentalize more effectively, being fully present, whether in court or at home. Professional recognition came steadily. The Bar Association honored me for innovations in case management. Harvard Law invited me to speak on judicial efficiency. Legal publications occasionally featured my more noteworthy opinions. What once felt like an impossibly premature appointment now seemed validated by performance. Dad visited, often delighting in his granddaughter and proudly following my career. When Lily was 3, however, he began experiencing puzzling symptoms. Diagnosis came swiftly and brutally: aggressive pancreatic cancer. Treatment options were limited, prognosis poor. I took emergency family leave, arranging for visiting judges to cover my docket. Those final months with Dad were precious and painful. We reminisced about mock trials at the kitchen table, his courthouse visits, and the unwavering support he had provided throughout my journey. He made me promise to show Lily the same encouragement he had always given me. "You were the best thing I ever did in this world, Annie Bear," he whispered near the end. "I am so proud of the woman, the judge, the mother you have become." He passed peacefully one autumn morning, Lily napping against his side, my hand holding his. The funeral service overflowed with clients he had helped, colleagues who respected him, and community members touched by his kindness. I delivered the eulogy with James standing supportive beside me, Lily solemn in her black dress. Mom attended briefly, arriving late and departing immediately after the service. Her condolence was awkward, formal, as though addressing a distant acquaintance rather than a daughter who had just lost her father. Harold stood uncomfortably beside her, checking his watch repeatedly. "Thomas was always dedicated to his principles," she said stiffly. "Catherine has a volleyball tournament this afternoon. We should be going." Grief overwhelmed me in unexpected waves during the months that followed. I returned to work perhaps too quickly, seeking the structured comfort of legal procedures. James worried silently, taking on more household responsibilities as I processed my loss. Judge Franklin recognized the signs, having lost her own father years earlier. "The law will still be there tomorrow, Annie," she said gently after finding me working late one evening. "Go home to your family. That is what Thomas would want." Slowly, I found a new normal. Dad's absence remained an ache that never fully subsided, but life continued. Lily started kindergarten. James received tenure. I marked 5 years on the bench with growing confidence in my judicial voice. We established a scholarship in Dad's name at Boston University Law School for students pursuing public interest law. Then my cousin Sarah called, her voice breaking with tears, and everything changed again. Sarah and I had been close as children before her family moved to Arizona. Though distance limited our interaction to holiday cards and occasional phone calls, we had reconnected more consistently after Dad's funeral. Her voice that night immediately alarmed me. "Annie, I do not know who else to call," she sobbed. "Brian hit me again. Emma saw everything this time. We need somewhere to go." Brian, Sarah's husband of 9 years, had struggled with prescription painkiller addiction following a construction accident. The sweet, hardworking man she had married had gradually transformed into someone volatile and unpredictable. Their 7-year-old daughter, Emma, had become increasingly withdrawn and anxious. "Come to Boston," I said without hesitation. "You can stay with us as long as you need." They arrived 2 days later, Sarah with fading bruises and Emma clutching a worn, stuffed rabbit. James immediately made them feel welcome, setting up our guest room with fresh linens and taking Emma to the park to give Sarah space to talk. The situation was worse than initially described. Brian's addiction had escalated to heroin. Family savings had vanished. His wealthy parents enabled his behavior, blaming Sarah for their son's struggles rather than holding him accountable. They had significant resources and political connections in their community. "They told me no one would believe me," Sarah whispered, "that they would make sure I lost Emma if I tried to leave." As a judge, I could not personally represent Sarah, but I connected her with Catherine West, a brilliant family law attorney who had appeared in my court. Catherine agreed to take the case pro bono after hearing Sarah's story. The initial legal proceedings moved swiftly. Catherine secured a temporary restraining order against Brian and filed for emergency temporary custody of Emma. Sarah found part-time work at a local bookstore, while Emma enrolled in school near our home. Slowly, they both began to show signs of healing in a safe environment. Then came the first shocking development. Mom called something that had happened perhaps twice since Dad's funeral. "Annie, I understand you are harboring Sarah and her daughter," she began without greeting. "I think you should know there are two sides to every story." Bewildered, I asked how she even knew about Sarah's situation. "Harold and I attended a fundraiser last weekend. Gregory and Patricia Wells were there. Brian's parents." She clarified unnecessarily. "They are devastated by Sarah's abduction of their granddaughter. Brian has been in recovery for months." Ice formed in my stomach as the implications became clear. My mother had somehow aligned herself with Brian's family against Sarah, against her own niece. "Mom, I have seen the medical reports and police records. Sarah has documentation of years of abuse. Young women sometimes exaggerate domestic disputes when seeking advantage in divorce proceedings," she replied dismissively. "The Wells family has assured me that Brian is committed to rehabilitation and being a father to Emma. They have asked me to speak with you about facilitating Emma's return." I ended the call as professionally as possible, immediately warning Catherine about this unexpected connection. She looked troubled. "The Wells family has significant influence. If they have recruited your mother as an ally, they may be building a more aggressive case than we anticipated." Within days, we discovered the extent of Mom's involvement. Not only had she befriended the Wells family, but Harold's investment firm had also quietly begun financing Brian's legal team, which now included a high-profile custody attorney from New York. The betrayal stung deeply, though I should not have been surprised. Mom had always resented my relationship with Dad, and by extension with Sarah, who had been his brother's daughter. Now she had found a way to position herself advantageously with a wealthy, connected family, while simultaneously undermining me. The custody battle intensified rapidly. Brian's attorneys filed motions challenging Sarah's fitness as a parent, citing her current unemployment and unstable living situation. They demanded immediate return of Emma to Arizona. Catherine countered with evidence of Brian's addiction, the documented abuse, and Emma's improving emotional state in Boston. The pressure began affecting Sarah visibly. She lost weight, developed insomnia, and jumped at unexpected sounds. Emma regressed, beginning to wet the bed again and experiencing nightmares. I felt increasingly helpless, constrained by my judicial position from taking more direct action. Catherine called one evening with alarming news. "Brian's team has filed a motion to have the case transferred to the Massachusetts Family Court in your district. They are claiming Sarah deliberately fled to your jurisdiction to gain unfair advantage." The strategy became clear: force the case into my district, requiring my recusal due to family connection. Then use that recusal to paint Sarah's relocation as manipulative. It was legally dubious, but potentially effective in creating harmful narrative. I immediately filed formal recusal documentation citing close family relationship with a party in the case. The matter was assigned to Chief Justice Robert Pearson, a fair-minded jurist with 30 years of experience. Though I had worked with him professionally, we had no personal relationship that would suggest bias. As the hearing date approached, Sarah grew increasingly fragile. "What if they take Emma?" she whispered one night after her daughter had finally fallen asleep. "The Wells family can offer her everything materially. I can barely afford an apartment right now." "Money is not the only measure of parental fitness," I assured her, though private concerns gnawed at me. The legal system I had dedicated my life to sometimes failed the very people most in need of protection. The evening before the hearing, Catherine called with one final disturbing update. The witness list for tomorrow includes a last-minute addition, Evelyn Preston. My mother had agreed to testify against Sarah, against her own family. The betrayal should no longer have had the power to wound me, yet somehow it still did. The morning of the custody hearing dawned bright and cold. Sarah dressed carefully in a borrowed suit, hands trembling as she fastened small pearl earrings that had belonged to my grandmother. Emma remained at home with James and Lily, a school holiday providing convenient timing. "You look perfect," I assured Sarah as we prepared to leave. "Professional but approachable. Just tell the truth exactly as Catherine has prepared you." "What if I see Brian? What if I freeze up?" "Catherine will object if questioning becomes abusive. Chief Justice Pearson is fair. Focus on him when you answer, not Brian or his attorneys." We arrived at the courthouse early, using the judicial entrance to avoid media. Though I had no official role in the proceedings, my presence as support for Sarah had been cleared with court administration. Catherine met us in a small conference room for final preparation. "The Wells family arrived 10 minutes ago. With Brian," she informed us. "Your mother is with them." Sarah paled visibly but straightened her shoulders. Years of enduring Brian's abuse had given her a core of steel beneath the fragility. The courtroom was more crowded than anticipated for a family matter. Brian sat with his parents and 2 attorneys at the respondents' table. His appearance shocked me. Clear-eyed and well-groomed, dramatically different from Sarah's descriptions of his recent condition. The Wells had clearly invested in extensive rehabilitation and image consultation. My mother sat directly behind them, elegantly attired in a designer suit, her silver-streaked hair perfectly styled. She did not acknowledge our entrance. Chief Justice Pearson called the proceedings to order promptly. Opening statements established the battle lines clearly. Catherine presented Sarah as a devoted mother protecting her child from an abusive, addicted father. Brian's attorney portrayed him as a recovering addict committed to family reunification with Sarah, characterized as vindictive and unstable. Sarah testified first voice, initially wavering but growing stronger as she recounted specific incidents of abuse, Brian's escalating addiction, and her efforts to shield Emma from the worst of it. Catherine guided her through presenting medical records, police reports, and Emma's school documentation showing behavioral issues coinciding with incidents at home. Cross-examination was brutal. Brian's attorney, a sharply dressed woman named Veronica Slater, attacked Sarah's credibility relentlessly. "Is it not true that you have been treated for anxiety and depression, Mrs. Wells?" "Yes, after years of living with addiction and abuse." "And you are currently unemployed except for part-time work, correct?" "I am working while establishing ourselves in a new city." "You have no permanent residence, no significant income, and are dependent on relatives for support. How do you plan to provide stability for Emma?" Each question targeted Sarah's vulnerabilities. Catherine objected when possible, but much of the questioning, while aggressive, remained legally permissible. By the time Sarah stepped down, she appeared drained but had maintained her composure. Brian's testimony presented a carefully constructed narrative of redemption. He admitted past mistakes but emphasized his current sobriety, attendance at daily support meetings, and commitment to being a present father. His parents testified about the stable home and excellent schools awaiting Emma in Arizona, along with their willingness to provide supervision and support during Brian's continued recovery. Throughout these testimonies, I maintained a neutral expression, though internally I seethed at the sanitized version of events being presented. Emma's court-appointed guardian ad litem provided some balance, noting the child's expressed fear of returning to her father and improved emotional state since arriving in Boston. Then came the moment I had been dreading. The court officer called the respondent calls Evelyn Preston. My mother walked to the witness stand with perfect posture, swearing the oath with practiced dignity. Brian's attorney approached with a respectful smile. Mrs. Preston, could you please state your relationship to the parties in this case? Sarah Wells is my niece by marriage. Annie Collins is my daughter. And how would you characterize your niece's current living situation? Mom glanced briefly in my direction before answering. Sarah and Emma are staying with my daughter and her husband temporarily. It is not a sustainable arrangement. Why do you say that? Annie and James both work demanding professional jobs. They have a young child of their own. Adding 2 more people to their household indefinitely creates significant strain. Each word was technically accurate, yet deliberately misleading. We had never complained about Sarah's presence, or indicated any timeline for her departure. In your observation, does Sarah have a realistic plan for independence? I do not believe so. She has limited employment prospects, and seems to be relying primarily on Annie's assistance. And how would you characterize that assistance? Here my mother paused, and I saw something harden in her expression. Annie has always been impulsively generous, but lacks practical planning. This situation follows that pattern. Could you elaborate, Mrs. Preston? My daughter tends to make emotional decisions without considering long-term implications. She is creating false expectations for Sarah about building a new life here when realistically Sarah lacks the resources or skills for self-sufficiency in Boston. Catherine stood. Objection. The witness is not qualified to assess the plaintiff's employment prospects or capabilities. I will allow it as character testimony regarding the support system Chief Justice Pearson ruled. Continue, Mrs. Preston. Mom straightened imperceptibly. Sarah would be better served reconciling with her husband under appropriate supervision. The Wells family can provide financial stability and proper therapeutic support for both Sarah and Emma. My daughter's involvement, while well-intentioned, is ultimately detrimental. The questioning continued, each answer more damaging than the last. Then came the statement that stopped the room. Mrs. Preston, in your opinion, is your daughter providing a stable influence for Sarah and Emma? Mom looked directly at me for the first time. Number Annie has always struggled with stability herself. She can barely hold a job. Her impulsive nature makes her an unreliable support system for a vulnerable family situation. Murmurs spread through the courtroom. Catherine rose immediately. Objection. This characterization is demonstrably false. Sustained Chief Justice Pearson replied sharply. Mrs. Preston, please limit your testimony to factual observations. But Brian's attorney pressed on. You mentioned your daughter has difficulty maintaining employment. Could you clarify that statement? Before Catherine could object again, Mom elaborated. Annie has never demonstrated the commitment required for long-term professional success. She has been terminated from multiple positions and tends to blame others for her failures. While she means well, she lacks the stability and judgment needed in this situation. The courtroom had grown completely silent. I sat frozen, the blatant lies too shocking to process immediately. Sarah gripped my hand under the table, her expression horrified. Chief Justice Pearson was studying my mother with an increasingly troubled expression. He glanced toward me, then back to the witness stand. Mrs. Preston, Brian's attorney continued. Would you consider your daughter's home an appropriate environment for a child recovering from trauma? I would not. Annie's personal instability and work history suggest— Your Honor, Catherine interrupted forcefully. This testimony is not only irrelevant, but contains demonstrably false statements about Judge Collins' professional history. At that moment, the courtroom doors opened and James slipped in, having arranged childcare for Lily and Emma. His eyes widened as he absorbed the scene, quickly moving to sit behind me. Chief Justice Pearson raised his hand. Miss Slater, this line of questioning seems designed to malign a respected member of the judiciary rather than address the matter before this court. Your Honor, Mrs. Preston's testimony speaks directly to the support system available to the plaintiff. If that support is unreliable— I have heard enough, Chief Justice Pearson said, his voice cutting through the tension. He set down his pen and looked directly at my mother. Then he stood, something I had never seen him do during testimony in over 1,000 cases. "Mrs. Preston, are you aware that your daughter, Judge Annie Collins, has been a federal judge in this district for 8 years? The courtroom fell absolutely silent. My mother's face drained of color so rapidly I momentarily feared she might faint. Her mouth opened but no words emerged. Chief Justice Pearson continued, his voice measured, but carrying unmistakable authority. Judge Collins was appointed to the federal bench at age 26, following an exemplary academic career and distinguished service in private practice. She is the youngest federal judge appointed in this district in over 40 years and has established a reputation for exceptional legal scholarship and judicial temperament. Mom finally found her voice, though it emerged strangled and thin. I was referring to earlier positions before her current appointment. Mrs. Preston court records indicate Judge Collins proceeded directly from a prestigious clerkship with Judge Margaret Franklin to her federal appointment. Prior to that, she was employed by Harrington, Walsh, and Bennett, where she was on partnership track before accepting the clerkship. At no point does her record reflect termination from any position. Would you care to clarify your previous statements? My mother's hands clutched the railing of the witness stand. There may have been some confusion about her employment history. Confusion, Chief Justice Pearson repeated flatly. Mrs. Preston, this court does not look favorably upon witnesses who provide false testimony, particularly when that testimony appears calculated to damage the reputation of a federal judge. He turned to Brian's attorney. Miss Slater, as an officer of the court, you have an obligation to ensure witnesses do not present knowingly false information. Did you verify these claims about Judge Collins before allowing this testimony? Veronica Slater had the grace to look uncomfortable. Your Honor, we relied on Mrs. Preston's personal knowledge of her daughter. I see. Chief Justice Pearson's expression suggested he saw entirely too much. The court will take a 15-minute recess. When we reconvene, the witness's testimony regarding Judge Collins will be stricken from the record and we will proceed with relevant testimony only. As the gavel struck, the courtroom erupted in whispers. Catherine leaned toward me. Are you all right? I nodded mechanically, still processing what had occurred. James moved quickly to our table, placing a supportive hand on my shoulder. I came as soon as Teresa arrived to watch the girls, he murmured. Sarah texted me what was happening. The three of us moved to a private conference room Catherine had reserved. Sarah was shaking with a mixture of anger and shock. How could she lie like that, about her own daughter, in court under oath? I had no answer that could make sense of my mother's behavior. James paced the small room, uncharacteristically agitated. This goes beyond family dysfunction, Annie. She committed perjury in a federal court. There could be serious consequences. I do not want to pursue that, I said quietly. It would only escalate an already painful situation. And Catherine frowned. Her testimony damaged Sarah's case by attempting to undermine your credibility as a support system. As Sarah's attorney, I need to address that. Focus on Emma, I insisted. That is what matters. Challenge the relevance of Mom's other statements without drawing more attention to the lies about me. Our strategy session was interrupted by a knock at the door. A court officer informed us that Chief Justice Pearson requested my presence in his chambers immediately. James squeezed my hand supportively as I rose to follow. The Chief Justice was standing at his window when I entered, hands clasped behind his back. He turned with an expression of genuine concern. Judge Collins, I want to personally apologize for what occurred in my courtroom. Had I known the nature of Mrs. Preston's intended testimony, I would never have permitted that line of questioning. Thank you, Your Honor. I appreciate your intervention. I must ask, do you wish to file a formal complaint regarding the perjured testimony? It would be fully justified under the circumstances. I shook my head. My only concern is that it not negatively impact Sarah's case. It will not, he assured me. If anything, Mrs. Preston's willingness to present false testimony calls into question the credibility of her other statements supporting the respondent. When I returned to the conference room, Catherine was reviewing notes while Sarah stared blankly at the wall. James immediately stood, searching my face for clues. The Chief Justice wanted to apologize, I explained. He also indicated Mom's testimony likely damaged Brian's case rather than helped it. A court officer appeared at the door. Recess is ending. Chief Justice Pearson requests all parties return to the courtroom. As we gathered our things, the officer added, Judge Collins, your mother is waiting in the hallway. She has requested to speak with you before proceedings resume. James stepped protectively closer. You do not have to talk to her. I know. I squared my shoulders. But I will, briefly. Mom stood near a window at the end of the corridor, her perfect posture now rigid with tension. She did not turn immediately when I approached. Annie, she finally said, her voice lacking its usual confidence. I need to explain my testimony. You need to explain why you committed perjury in federal court. Why you deliberately attempted to damage my professional reputation. Or why you betrayed Sarah and Emma to align yourself with their abuser. My voice remained low and controlled the same tone I used when addressing contempt issues in my own courtroom. You have never understood how the real world operates, she replied, defensive despite her vulnerable position. The Wells family has significant influence. Their foundation funds programs Harold's firm invests in. Sarah made a serious mistake leaving Arizona without proper legal arrangements. So you decided to sacrifice her and Emma to maintain social connections and fabricate lies about me in the process. I may have misspoken about certain details of your employment history. Misspoken. The word emerged as a harsh whisper. You stated under oath that I was fired from multiple positions, that I can barely hold a job. You deliberately lied to undermine my credibility and, by extension, Sarah's case. I was trying to create perspective about the practical realities of Sarah's situation. James had maintained a respectful distance but now moved to my side. Mrs. Preston, with respect, what you did today was not only harmful to your daughter and niece, but potentially criminal. Perjury carries serious penalties. Mom's expression hardened. Are you threatening me, James? No, I interjected. He is stating facts, something you should have considered before testifying today. The 2-minute warning bell sounded for court reconvening. Mom straightened her jacket, composure returning like armor. I stand by my assessment that Sarah should return to Arizona where proper resources exist for her situation. Your emotional involvement clouds your judgment, Annie. It always has. She turned toward the courtroom, without waiting for response. James placed a steadying hand on my back as we watched her walk away. Are you all right? He asked softly. No, I admitted. But Emma and Sarah need us focused on the outcome of this hearing, not on my mother's betrayal. We returned to the courtroom as Chief Justice Pearson resumed the bench. The atmosphere had shifted noticeably, with Brian's attorneys in intense whispered conversation. My mother had returned to her seat but now sat slightly apart from the Wells family. Before we continue, Chief Justice Pearson began, I wish to address a matter of court procedure. Testimony was presented earlier that contained demonstrably false information about Judge Annie Collins, who is present today as support for the plaintiff but has no official role in these proceedings. That testimony is hereby stricken from the record in its entirety and will not be considered in my ruling. He fixed Brian's legal team with a stern look. Furthermore, Mrs. Evelyn Preston is dismissed as a witness. Any party who knowingly presented false testimony may be subject to separate proceedings regarding potential perjury charges. Veronica Slater rose immediately. Your Honor, Mrs. Preston was called in good faith based on her familial connection to the parties. If certain aspects of her testimony were inaccurate, we had no prior knowledge of those inaccuracies. So noted, Chief Justice Pearson replied without inflection. We will proceed with the remaining witness, Dr. Lawrence Brenner, the family evaluation specialist. The rest of the hearing proceeded with clinical testimony from Dr. Brenner, who had interviewed Emma, Sarah, and Brian separately. His assessment provided objective support for Sarah's position, noting Emma's anxiety symptoms appeared directly correlated to contact with her father. Catherine's cross-examination strengthened this testimony further, having Dr. Brenner elaborate on specific trauma indicators observed in Emma and the potential harm of forcing her return to a triggering environment regardless of current supervision arrangements. By the time closing arguments concluded, the momentum had shifted palpably in Sarah's favor. Chief Justice Pearson announced he would issue his ruling the following morning, thanking all parties for their participation. As we gathered our materials to leave, I noticed my mother had already departed. The Wells family exited without acknowledging us, Brian's face tight with controlled anger. Only Catherine's cautious optimism offered any comfort as we left the courthouse through a side entrance to avoid potential media interest. The Chief Justice's reaction to your mother's testimony may have been the turning point she observed as we reached the parking garage. Sometimes cases hinge on unexpected moments of clarity. That evening, our home felt like both sanctuary and fortress. James prepared comfort food while Sarah helped Emma with homework, maintaining routine despite the day's tension. After the children were asleep, the three of us sat in the living room with untouched glasses of wine. "What happens if we win?" Sarah asked suddenly. "Brian's parents will never stop trying to regain control. They have unlimited resources." "One step at a time," I counseled. "A favorable custody ruling gives you legal foundation. We can address ongoing concerns with proper protections in place." "And your mother?" Her voice faltered. "Will she face consequences for lying in court?" James and I exchanged glances. "That depends on whether Chief Justice Pearson refers the matter for prosecution," I explained. "But regardless of legal consequences, I believe we need to establish clear boundaries going forward." The uncertainty hung heavy as we finally sought rest tomorrow's ruling, looming as both promise and threat. The following morning brought both anxiety and hope as we returned to the courthouse. Chief Justice Pearson entered promptly at 9, his expression giving no indication of his decision. Having reviewed all testimony and evidence presented in this matter, the court finds it in the best interest of the minor child Emma Wells to remain in the primary physical custody of her mother, Sarah Wells. Sarah's hand flew to her mouth, tears immediately welling. Catherine squeezed her shoulder supportively as the ruling continued. "Mr. Brian Wells shall be granted supervised visitation, initially at the Supervised Family Center in Boston, progressing to unsupervised day visits contingent upon consistent participation in substance abuse, treatment, and completion of a TAEVA parenting program addressing domestic violence issues." The Chief Justice detailed additional requirements. Brian's continued sobriety verification, communication restrictions, and a prohibition against removing Emma from Massachusetts without court approval. The Wells family sat stone-faced as each provision further secured Emma's safety and Sarah's authority. This court notes with concern the testimony attempting to undermine the plaintiff's support system through demonstrably false statements. Such testimony has actually strengthened the court's conviction that the plaintiff has secured appropriate assistance during this transition period. With a final strike of his gavel, Chief Justice Pearson concluded the proceedings. Brian's parents immediately surrounded their attorneys in intense conversation, while Brian himself sat motionless staring at the table before him. Catherine guided us quickly from the courtroom. "This is an excellent outcome, better than we might have hoped. The supervision requirements will be difficult for Brian to challenge without substantial demonstrated improvement." In the courthouse corridor, James waited with a broad smile. "Good news. Full custody to Sarah with highly restricted visitation for Brian." Catherine confirmed. The Chief Justice essentially gave us everything we requested. The drive home passed in a blur of emotions. Sarah alternated between tearful relief and anxious planning for their future. By afternoon, Emma had been collected from school and told of the decision in age-appropriate terms. Her response was telling a long, silent hug for her mother, followed by the first genuinely carefree play session we had witnessed since their arrival. That evening, friends gathered to celebrate. Judge Franklin brought champagne and practical advice about navigating co-parenting under court supervision. Catherine joined, briefly bringing contact information for support groups for both Sarah and Emma. Even Teresa the nanny stayed late, Lily and Emma giggling together over special desserts. As our home gradually quieted, the emotional weight of the previous days settled fully upon me. The custody case was resolved favorably, but my mother's betrayal remained a raw, unprocessed wound. James found me on the porch swing, staring into darkness. "You have been taking care of everyone else," he observed, sitting beside me. "How are you really doing?" The question broke something inside me. Years of maintaining composure, of meeting my mother's impossible standards, only to be betrayed so publicly, suddenly overwhelmed my carefully constructed professional demeanor. I cried in earnest for the first time since Dad's death, James holding me silently through the storm. "I keep thinking I should be used to her disappointment by now," I finally whispered, "that it should not still hurt this much." "There is no statute of limitations on parental wounds," he replied gently, "especially when they are deliberately inflicted." In the weeks that followed, Sarah and Emma began building their independent life. With Catherine's help, Sarah secured a restraining order against the Wells family, preventing them from approaching Emma outside official visitation. She found a small apartment near us and enrolled in a paralegal certification program, building on skills from her previous office experience. Emma started therapy with a specialist in childhood trauma, gradually showing signs of recovering her natural resilience. Her nightmares decreased, her school performance improved, and she began forming friendships with neighborhood children. I returned fully to my judicial duties, but found concentration difficult. Mom's false testimony replayed in my thoughts during quiet moments. Colleagues who had heard about the incident were supportive but curious, creating uncomfortable awareness that my private family dysfunction had become public knowledge in legal circles. After 3 weeks of increasing distraction, James suggested professional help. "You counsel others to seek therapy when needed. Perhaps it is time to take your own advice." His gentle challenge led me to Dr. Caroline Blake, a therapist specializing in family estrangement and professional women's issues. Our initial sessions focused on separating my judicial identity from personal family dynamics, recognizing that Mom's behavior reflected her limitations, not my worth. "Your mother's testimony was not actually about you," Dr. Blake observed during our 4th session. "It was about her need to align with wealth and influence, even at the expense of truth and family loyalty." This perspective slowly helped reshape my understanding of the courthouse incident. The betrayal remained painful, but became less personally defining, more clearly a reflection of Mom's values than my achievements. 3 months after the custody hearing, an envelope arrived with Mom's distinctive monogram stationery. I stared at it for days before discussing it in therapy. "You do not have to read it, Doctor," Blake reminded me. "Opening communication remains your choice, not her right." After careful consideration, I decided to read the letter during our next session, providing immediate professional support for whatever it might contain. The contents were predictably disappointing. Mom acknowledged certain inaccuracies in her testimony, but attributed them to confusion and miscommunication rather than deliberate falsehood. She expressed concern about potential social awkwardness at upcoming charity events where our paths might cross. The closest approximation to an apology came buried in a paragraph about family obligations I regret if my testimony caused unnecessary complications. No genuine acknowledgement of harm. No real accountability. No meaningful change. Dr. Blake watched my expression as I finished reading. "What are you feeling right now?" "Clarity," I answered after careful reflection. "This letter confirms what I need to accept. My mother is constitutionally incapable of honest self-examination or genuine remorse. Continuing to hope for that is setting myself up for repeated disappointment." That realization, painful as it was, provided foundation for establishing healthier boundaries. I responded with a brief, professionally drafted letter outlining my expectation of no contact for the foreseeable future. I specified that any necessary family communication should be directed through James, with no exceptions for holidays or social events. "You are not punishing her, Doctor," Blake affirmed when I shared my response. "You are protecting yourself from proven harmful behavior. There is an important distinction." Over the following year, healing took many forms. Sarah completed her paralegal certification and secured a position with Catherine's firm, showing natural aptitude for family law support work. Emma thrived in her new school, her artwork depicting increasingly bright colors and hopeful themes. Lily adored her cousin's sister and protested dramatically when they moved to their own apartment. My professional standing remained secure, with Chief Justice Pearson personally ensuring that my mother's false testimony created no lasting damage to my reputation. Judge Franklin increased our mentorship activities, jointly establishing a program for female law students interested in judicial careers. In memory of Dad, I began teaching a pro bono evening class at Boston University Law School, helping students interested in public interest careers navigate financial and practical challenges. This connection to his legacy brought comfort and purpose, transmuting grief into constructive action. The Wells family made several attempts to challenge the custody arrangement, each failing due to Brian's inconsistent participation in required treatment programs. When Sarah was promoted to senior paralegal, she moved Emma to a neighborhood with an excellent school district, creating further stability for their future. Approximately 1 year after the courthouse confrontation, I received an invitation to speak at a judicial conference in Chicago. The topic, Maintaining Judicial Objectivity When Legal and Personal Matters Intersect, spoke directly to my experience. After consultation with Dr. Blake and James, I accepted. My presentation addressed the challenges judges face when their personal and professional worlds collide, using carefully anonymized aspects of my experience to illustrate key points. The response was overwhelmingly positive, with many colleagues sharing similar family complexities previously kept private. That conference marked a turning point in my relationship with my experiences. What Mom had intended as destruction had ultimately created opportunity for growth, connection, and deeper understanding of the human dimensions of legal practice. On Emma's 8th birthday, we hosted a celebration in our backyard. Sarah had blossomed into confident single motherhood. Judge Franklin attended briefly, bringing an elaborate dollhouse that reduced Emma to speechless delight. Even Catherine joined, her professional relationship with Sarah having evolved toward friendship. Watching these strong women gather in support of Emma's future, I reflected on the family we create through choice rather than blood. Dad would have loved this gathering, these relationships formed through mutual respect and genuine care rather than obligation or advantage. Later that evening, after guests departed and children slept, James found me in my home office. I was looking at a photograph taken at my judicial appointment ceremony. Dad beaming beside me while Mom stood slightly separate, expression carefully neutral. "Good memories?" James asked, massaging my shoulders gently. "Mixed," I admitted. "But I am finally making peace with that. Not every family story has a perfect resolution. Some have better endings than they might have," he observed. "Sarah and Emma are thriving. You have turned painful experiences into wisdom that benefits others. Your father would be incredibly proud of the judge, the mentor, the friend you have become." His words resonated with truth. The journey from that shocking courtroom moment to this peaceful evening had been difficult but ultimately transformative. My mother's betrayal had revealed the strength of the community surrounding me, the resilience I had built over years of meeting challenges. In my chambers now hangs a simple framed quote, "Justice is truth in action." Below it sits a photograph of our extended chosen family, James and Lily Sarah, and Emma Judge Franklin, and several close colleagues who supported us through difficulty. This visual reminder serves as daily affirmation that true family transcends biology, built instead through consistent love, respect, and presence. Have you ever had to create boundaries with family members who repeatedly hurt you? How did you balance forgiveness with self-protection? Share your experiences in the comments below. Remember that healing is not linear, and sometimes the family we choose brings greater support than the one we were born into. If this story resonated with you, please subscribe and share with someone who might need to hear that success is the best response to those who underestimate you. Thank you for listening to my journey from betrayal to healing, and I wish you strength in your own path forward.